When they bought the original canvas of the
Right.
original painting, don't they own it at that point?
They own that canvas, but they don't own the right to reproduce it.
Killing me. Ah! Now we have questions from the internet and we have questions from live, so let's do it.
Just one quick question. So I had this happen to me where someone, this is a while back, stole my portfolio site and represented it as their own.
Ooh, that's a good horror story.
No, it's
I
really
like that one. That was a great one.
But the question is, obviously this person was sketchy. What recourse
wasn't Mark,
is there
was it?
really in a person that's doing that kind of thing? Like, you know what I mean? I hunted it down
That's a
and
great
figured
question.
out that they're like in Grand Rapids, Michigan. It's clearly someone that's just scraping the bottom of the earth, trying to do stuff to literally, like, steal all the images and copy and represent it as their own agency. So there was nothing for me to do.
Well, there always is. You can sue them.
But if they have nothing.
It still may stop them. And often, I've found, if you write a letter, a nasty gram, a cease and desist, good people will comply with it. But people that have stolen your entire portfolio and portrayed it as their own, I don't know if they're going to be so intimidated by that. Or they may think, okay, if I get the letter, then I'll stop. But you're certainly not going to get paid from that. Sometimes I'll just sue because it's a $450 filing fee. And we'll draft a complaint up, and it's pretty easy to show this is your work and this is what they're stealing. Serve it on them, that ding-dong.
You're just mad. Because tonight you suckers got served.
I didn't have a cap there.
And in federal court, because I'd sue under trademark and copyright claims there for false advertising, because it's not their work that they're advertising, and for copyright infringement for your work, they're in federal court. I'll sue them here in Los Angeles, serve them in Michigan, and even if they don't respond, I can get a default judgment against them, and
Actually, can I ask a
and
follow-up
then
on
I'll
that?
get them to stop.
So let's say some of these like past clients where you didn't get paid. I had a couple of those too in my career.
Okay.
Didn't go after them. I figured it was a waste of time. But let's say I had taken them to small claims and got a judgment. So what's the process there? So like, let's say you go to small claims and put in something for $7,500 or $10,000 and win.
Okay.
So then how do you get?
Now you have to collect.
Yeah. How
Then
do
you
you
have
do that?
to collect. You have a judgment. And the judgment allows you to seize assets. And you then go to court. You first have to find some assets, say a bank account. And you tell the judge, I want to seize the assets in this bank account. And you get a court order, and you have that court order served on the bank, and the bank will give you the money. This is why cases settle.
Now, have you done this before? Have you been able to successfully seize assets? See, this is the problem. It's the problem. Yeah, it depends.
It
like a little kid in a garage.
The
What are you
sketchier
gonna do?
people are hard to find. I've been on the receiving end
Yeah.
of clients that have had judgments against them where they had assets to protect, and I had to negotiate out of it.
Right.
And I have clients that I wasn't involved that have told me that they operated a retail storefront where they had cash registers, and literally one day the sheriff shows up and sits on the cash register, and at the end of the day, scoops out the cash to help satisfy the judgment. But it depends. One thing I used to leverage is people's domain names, because they a lot of times are very married to that, and that's heavily invested. And they'll say, I have no money, what do I care? Go get your judgment. I'll say, okay, but I'm going to seize your domain name. But it's my, this is my whole identity, and then you can sometimes get a compromise. It's about having some leverage. But I find domain names work, or their artwork. I'm saying, don't you have copyrightable materials I can take? And they go, wait, you mean my art? I'm like, yes.
Hey, what's your name again? Rob? Rob, so here's what I think. This is just my lame kind of outsider point of view. The legal system works for a certain size company and a group of people. It's not like for you and me. It doesn't seem like it, okay? Like when you're in like 100 to many billion-dollar companies, they sue each other all the time. Samsung sues Apple, Apple sues Samsung. This is how they do it. Money's exchange hand. People stop ripping each other off, and that's what happens. But you sue a guy who's like tiny in Podunk, USA. He's got no money. You spent 6 months chasing this money. It's not going to come to you. So I just feel like it's designed for like a whole different group of people. Now, I've been pulled into the system and been educated in it, but it's weird. So look, I think you should send a cease and desist, try and take some action just to get us to stop. You're not going to get punitive damage, so you have to kind of be mindful of how much money you're going to spend to try to get no money. And just be mindful of that.
Okay, so we have a question from Sean T, and he's saying, if a client pays me $10,000 for some work and he pays his designer $1,000, that doesn't look good to the client, right? So his question is, if he has an NDA with a staff person that he hires, can he legally make them not show that work on their portfolio?
Those are two different questions, but that's okay. That's cool. It's like Sean, I like it. Sean and I are friends, so there's two questions here. And the thing is, yeah, if you do get $10,000 and your staff is like telling everybody telling the client this is what you paid them, that's not cool. But what you're really asking there, Sean, I think, is if you can have your employees sign a non-disclosure agreement so that they can't use the portfolio anywhere else except for their own company, for his company. It's something like that.
If that's the question, absolutely.
What would you call that? What's the terminology?
Well, if they're an employee, and remember we talked about employer-employee versus an independent contractor, you can have policies in place as an employer where they sign, a lot of times it's on their first day of work, they'll sign an employee handbook. And I know I've worked
Do you know somebody that's got that?
I do. I work with Jesse creating your guys' employee handbook.
Yeah, we have an employee
handbook. It grew
handbook.
and grew and grew, but one of the provisions in it talks about you have to maintain the integrity of the business. You cannot disclose what goes on here. It's nobody else's business.
This is a hot topic. I'm gonna be all over fly and poop in a second. Go ahead.
So no, they're not supposed to disclose to your client what their salary is or how they got paid or anything like that. If it's a situation where, oh, I paid the designer $1,000, but my company got paid $10, sounds like you had an independent subcontractor. Still, you're still going to have an agreement with that person because either a work for hire agreement or something where they're assigning all the rights to you, so you can turn around and assign it to your client. And in that, you should have a non-disclosure agreement or a non-disclosure provision that says, you won't talk about any of the business aspects of our business or anything else that you might encounter during the course and scope of your work. Moreover, you'll have another provision that talks about portfolio use. And portfolio use is an ongoing discussion. And it is always an issue.
Here we go, guys. It's about to get bloody right about now.
And portfolio use is, hey, I did this. I want to show people. I have my website, and I have my YouTube page, and I have my Twitter, and I have my Instagram, and I want to put it up there. Not so easy. Because a lot of times, your client doesn't want you to do that. Some will say, well, we'll allow you, but after the fact. Right now, the contract says you can't without our written permission, which must be given in advance. But you want to be able to use it if you can as the company that's creating the work. Negotiate that. Make sure, because you don't want someone to be upset. As an employee or an independent contractor, one of the issues that I've seen is people want to be able to say they did it when they were actually working in a big environment with a whole lot of support. And the employer may or may not allow that, or they'll say, if you're going to, you have to give us credit.
And you burn in a watermark. There's a lot of things.
Right.
So
or a bug.
Yeah,
Yes.
the same thing. So you guys, here's the thing. Our group here, assuming, are more entrepreneurially minded. So these are more on the employer side than they are on the employee side. So that's another time, another place. But I want to talk about from the employer side because Sean just opened a whole can on us right now. And I want to talk about this. So it's a very common practice, especially in the motion design industry, for you to go work somewhere, get a nice salary, earn a comfortable living, and then when you feel like you've had enough, to walk away with that company's portfolio. And that's a practice that's super common. I don't think it's right. I don't think it's fair. Okay, and we've been in lawsuits, he and I, to protect the work. Because during the time in which people work here, they sign an employee contract, and there's certain things in there, maybe certain non-compete clauses, like you don't go after our clients, you don't go after my staff, you don't go and start hiring people that are in our group, and the rights to the work product. We talk about work for hire. When you work here, like at Disney, they own your intellectual property, they own everything, because they pay for everything. So you kind of have to be respectful of that. Now, we allow, on a case-by-case basis, people who've worked here to show their work, as long as they follow a list of procedures, to present it on their personal site. What really gets under my skin is when people take our work, and it's happened on multiple occasions, thank you very much, Frank Shi, on multiple occasions where they take the work and put it on another company's portfolio. Now that sends me through the roof. That's when I unleashed Stuart and I said, destroy them. I'm tired of this. Because they spent $0 producing that work, took zero risk, zero development costs, and they get to benefit from our work. And we got to put a stop to that.
Somebody wants to know if what happens if your subcontractor is outside of the United States?
Ooh, and there's an issue? Okay, so let's say this happens. I work with people in the UK and in Australia and all over the place, Canada. How does the law work there?
Well, the contract with that person is only as good as you can enforce it. And the problem with working with people overseas is, how do you enforce that contract? Legally, you have to sue them generally where they are. And depending on where they are, will tell you whether it's easy or hard to do so. Some countries will not respect a judgment in a U.S. court. So let's say you sued, even if you had a contract that said, we can sue you in Los Angeles, and we get a judgment, you still have to collect where their assets are. You remember we talked about collecting on a judgment. You got to find where they are. If they're not here, you've got to get a court in another country to collect on those assets. Certain countries are easier than others. Suing in Canada, not a problem. Suing in the EU, the UK, generally not a problem. Interestingly, suing in China is not a problem if you have the right contract. China won't respect judgments that are over here. But if you have a contract or an agreement that says, we agree that any lawsuit will take place in China, subject to the People's Republic of China's laws, in the locality where the company is that you're having your dispute with, surprisingly, American companies and other foreign companies have done well where they can show an actual breach of the contract. It all depends on the country they're from, but often you're using someone from another country because they're cheaper. With that comes risk.
You guys, let's end the madness. This is total insanity. You guys are not paying attention to anything we've been talking about. I'm going to reach out to you right now, internet audience. I'm going to pull you in here. It's like, get real. You're not going to sue anybody. It's not going to work. You can't collect from the guy in Podunk, USA. Forget about him like hiding in a hole in China somewhere. Let's be real. The legal system is not built for you. Get over it. Just get over it. It is risky to be in business. That's why not everybody does it, all right? My blood level's going up, I can tell right now, all right? Here's the deal. There's risk inherent in doing business. When you hire a subcontractor, sometimes they do the work for you, sometimes they don't. That's why you gotta charge more, because you assume certain risk. So the lesson here, and we've heard this in many different ways, is get your money up front, you guys. Protect yourself.
And pay at the end.
Pay at the end. Build into that a certain kind of fudge factor, if you will, that somebody's going to drop the ball and you're not going to get it back. So pay them incremental payments and get your incremental. See how it works? That's how it's going to work. Let's talk about fair use really quick. More likely than not, this is what you guys are screwing up right now. Isn't it fair use, Stuart? Okay, so let's be mindful. Let's keep this into like 3-minute boxes.
So I've asked this question dozens and dozens of times in lectures to schools all over the Southland to design students. And the question is simple this: what percentage of a work do you have to change in order to be allowed to use it? All right? So how many people will say 10%? All right, nobody. 25%, if you change it 25%, does that get it? Now, what's the magic number? Is it 36? 75. I hear 75.
Don't play into the game. Let him finish. Don't do it. Don't bite, dude.
The answer is none. You can't take someone else's work and create a new work from it. That is called creating a derivative work. And under 17 U.S. Code Section 106, the exclusive right to create derivative works lies in the author, the owner of the copyright. So it doesn't matter how much you change it, for the most part. And that's why people get in trouble. You may remember a famous poster from a few years ago where someone took a photograph of a
Obama. Let's just
politician.
say it. They know what it is. Let's just call it. We were talking about it on this show. We're talking about Shepard Fairey doing an illustration of an Associated Press photograph, and I believe he lost that case.
Well, what was interesting was Shepard Fairey was the one that actually did the suing. I always found that to be the most entertaining part of the story. Yeah, you see, the Associated Press photographer said, "You're using my photo." And he says, "Oh yeah, but I transformed it. I created art. And I did this whole thing, and it's now a phenomenon. And therefore, I don't owe you a penny." And the Associated Press guy's like, "Yeah, no, that's not right." The AP guy, if I recall correctly, was in Pennsylvania. Shepard Fairey was in New York. And I think someone said to him, "Look, you're going to get sued. Let's not get sued in Pennsylvania. Let's sue this guy in New York now first, so we get to pick our venue." And they filed suit in New York, and ultimately, I think it was pretty much determined that no, he didn't. He created a derivative work from someone else's existing work, and he needed a license. He didn't get one. And there is no amount. And if you look at it, I mean, who could even say what percentage he changed? I mean, that's my favorite part of the percentage. Well, I added some color. Well, that's 18%. Well, I added the word hope. Oh, well, that's another 27%. I mean, it makes no sense. You cannot.
So did he lose or win that case?
He lost.
He lost.
He lost.
Do you know what the damages were?
Ultimately, I don't know how. As you learn, when it comes to a point where it's like, ooh, I'm not going to win this, that's when everybody gets together in a room and they have their talk, and then they all go about their separate ways, because the whole, at the end of the day, court judgment thing can be difficult for all parties.
Right.
But the real issue is whenever you're going to use any pre-existing work, whether it's a film you're going to parody, or whether it's a person you're going to make fun of, or whether it's some work you want to use in some way, shape, or form, the simple question is, are you going to upset someone enough that they're going to do something about it? Because it doesn't matter whether you're going to win a lawsuit. At the end of the day, none of you can afford a lawsuit. Getting sued is losing. And so the question, and I get this question all the time, is, can I do this? And I'll say, will they be upset? And if the answer is, I don't know, then I'll say, can you afford a lawsuit? No, I don't want to get sued. Well, that's
He's killed
what
more
matters.
of my ideas than you can imagine.
That's what matters. If you don't want to get sued, then it gets back to Chris says, what's the risk?
Serial killer right here. I'm like, Stuart, can I do this? No. Get it? No.
And I'll never say no to you. I'll say, well, if you really want to do that, here's what could happen.
Sure.
Do you want that to happen?
That's usually enough to scare me away. I do want to tell you guys this because I do know this a little bit. In terms of fair use, we worked on a film called Room 247, which is based on the films of Stanley Kubrick. And this person broke down The Shining and all this kind of stuff. And there's a specialist in Hollywood, believe it or not, that helps you get the rights to use somebody else's film in the critique of the film. The argument is you can't critique the film without showing the film. So guess what? All the clips he used from Stanley Kubrick's films were free, fair use. The clips that weren't from the film is the ones he had to pay for, which is kind of ironic, right? So he had to pay for generic audience reaction shots or people in theaters. And so it's kind of interesting how he was able to produce that film. So that's fair use. He sought out the guy that does that, and that's how he did it. Now, Aaron, you have a question. Let's rock it out.
If you're producing like a commercial or a short movie or TV show or something, and someone else's brand shows up in your short, like let's say I'm in a kitchen and there's a Coca-Cola bottle and a hat, whatever, is that still covered? If I'm not defaming them or saying anything bad about him,
Okay.
is that still?
I'm sure Stuart can
is that
answer this one pretty
protected,
easily.
Or is that okay? Or
Good question. And let me just say my blanket statement, which is anyone can sue anyone for anything at any time. It's just a matter of whether they're upset enough to find the resources to do so. Certain companies, big studios, will get upset easier than others. But as far as, and you've seen this many times, the generic beer can or someone will or blur out a label on something. And you ask, oh, well, there must be a legal requirement for that. It's usually because if you are a TV show and you're showing bottles of Coors being drank by your actors, Budweiser's not going to be happy if they just paid $500,000 for a 30-second spot. So that's where the conflict comes in, and that's where the blurring comes in. The holding a brand out to ridicule, which is part of that question, making them look bad, tarnishing a brand, that obviously can cause someone to get upset with you. But the mere fact that in the course and scope of something you're using a branded bottle, because that comes up a lot, isn't necessarily illegal, but it's risky because you never know when someone might get upset. It's one thing if you're a very family-friendly oriented show, but if on the other hand, you're a very controversial show that a brand doesn't want to be associated with, they would be afraid that people would think that they paid to have the product placement in there. And that kind of association and risk is where, that's where the problems lie. And that's why it's better to clear things or to not use them, to obscure the labels and that sort of thing. Or the best, of course, is to actually get them to pay you to put the stuff in there, because that's pretty nice.
Hashtag product
But
placement.
if they do that, you must disclose it. There are certain FCC regulations for that.
Okay. So if you're making an independent film, Stuart, correct me if I'm wrong, and you're just shooting and you're not really trying to defame anybody, it's just part of your film, you don't have to genericize everything. But if you're talking about eventually cutting this into something you're going to be sold and there's sponsors involved, you might want to think ahead and then you do that. Or the best option is to get the whole sponsored content thing going. Okay? So there's different considerations. Now you guys know that's part of the story.
Can I tell a really quick fun story?
Yeah.
All right. So an artist, 2D painting, like fine artist, was watching a big motion picture, $100 million budget. And she's watching this, and it's, big movie. And she sees in the background of a scene a painting she had painted probably 20 years prior when she was a student in college. She hadn't seen the painting in 20 years, and she believes it had been in a storage facility that got foreclosed on, and so then they seize what you've stored, and then the thing ends up in probably a flea market, whereupon someone involved in the production said, I think I've got a great painting for this wall. And they bring it in, and actually in the scene, I think there was an explosion, so the painting got destroyed. So they actually copied it and recreated it, and they blurred out or just erased the signature. But it wasn't anything that they could trace back to the artist. The artist was not known. This was just something she had done years earlier. But she had a photograph of that painting in her possession. And there was absolutely no way she could have that photograph unless it was her. And she had a professor that remembered her painting it for an assignment in her class 20 years earlier. And I'm certain the people involved in the production were like, I found this thing at a flea market. It's fine. It's fine. Threw it up on the wall, and you never know where these things happen from.
You're like missing. You're leaving out the ending.
At the end
what
of the
happened?
day, we contacted the studio.
You represented her?
I represented her.
Wow.
We contacted the studio, and the studio was very, please don't sue. We'll work it out. We'll work it out. And what they eventually did was they paid her a license fee, and they actually went and got the painting and gave it back to her. They're like, hey, does she want the painting back? I'm like, I don't know. I'll find out.
Wait,
and,
what is the legal basis, Stuart? Are you like...
Copyright infringement.
How? I bought the painting.
Yeah, exactly.
But you don't own the rights to the underlying image. You only own the painting.
Oh, was this a
The
photo?
copyright.
Wait. They bought the original in the flea market, or
Yes.
just a picture of the
No,
original?
they bought an original painting.
Well,
when you
you-
buy an original painting, you own that painting. You
I told
actually
you.
don't own the copyright. The copyright subsists separate from the physical manifestation of the work.
Okay, look. Okay, there's two things we learned right now. You're screwed. The legal system is not for you, and Frank is moving back to China, where it's like the wild, wild west. That's really what it is, right, Frank? Yeah, not yet. All right.
But you've known many artists or painters
Oh my
that
gosh.
have painted an original work and then they've sold off prints or giclée or different, and they sign them and they'll make 1,000 of them. But the original might be sold to some
But wait,
patron of the arts.
The original, isn't that the manifestation of the idea, or is the idea the copyright?
No, it's the manifestation, the fixed
Okay.
the fixed
so
work.
When they bought the original canvas of the
Right.
original painting, don't they own it at that point?
They own that canvas, but they don't own the right to reproduce it.
The reproduction of it.
Yeah. They
Do you mean so
reproduced
when it was shown on TV, that's a reproduction of it?
Yeah.
Oh, it's killing me. Ah! Ah! The internet's going to break right now. All right, hold on. We got a couple of questions, and then we need to wrap up. Josh? Josh Jacobs. He's like a superhero. Josh Jacobs, man of power. Okay, so let's ask the first question. I'm a freelancer. I show up to Blind. Blind gives me a contract, which we have. Everybody who comes here has to sign paperwork. First day, you sign paperwork, okay? Now he says, how do I make that legally binding? Isn't it already legally binding, Stuart?
Well, an agreement is legally binding. It doesn't even have to be on paper. It could be oral. Enforcing the agreement is the hard part. It's easier to enforce an agreement where you know the intent of the parties going into it, which is reflected by the contract. Make sure everybody's on the same page, you sign the same page.
If you promise to book me for 5 days and pay me $400 a day,
Right.
you owe me $2,000. 2 days into it, you're like, we don't need you, and you send me on way. I'm like, whoa, we agreed. What can the employee, whether they're classified as an employer or freelancer, how do I just get paid? Just how do I get paid?
So you sue them in small claims,
But
or
what do you do to the agreement? How do you make sure you have a clear agreement?
the
between two
agreement
parties?
has to say my minimum fee is this, because what happens is if there's not a meeting of the minds, the employer will think I'm paying your day rate for however many days I'm going to use you. I gave you an estimate of 4 days. I was off my estimate, but it wasn't a promise or a guarantee. If you want guarantee for a minimum number of days, you got to say it, and that way both people are on the same page. Employer knows, okay, I'm booking him for 5 days, whether I use him or not, and the employee knows, okay, I'm not going to book anything else during that time. I'm not going to look because I got 5 guaranteed days.
So the short answer to that is have an agreement in writing. It doesn't even have to be that complicated. Just have a shared document so you guys can argue about it later if that happens to be the case. Now, can you collect it? Good luck, right? So let's get to the one question that he was really asking, all right? Which was what? Like you're a independent contractor and you have a client.
Then you have to make sure that you have a meeting of the minds. And a lot of times with creative people, they think, look, we're all creating art here. We're doing something for a higher purpose. We are making the world a better place. The oceans are going to recede and birds are going to fly and butterflies. And so
do that in your Morgan Freeman voice, though, at the end of Deep Impact, right? All right, never mind.
So there's no reason. We're all going to get along. We're going to sit around a campfire and sing. And so, of course, you're going to be good to me, and I'm going to be good to you. And so and if I bring a contract into it, and God forbid, lawyers, then it's going to kill the relationship. They're going to look at me not as an artist, but as a business person. And they're never going to want to work with me again. And it's all just going to go down the drain. So I'm better off just being an artist and hoping and praying that they'll treat me fairly. But the problem is they may have a different sense of what fair is. they may think, I'm paying you your day rate for however many days I'm working with you. Or the client may say, I'm paying you to deliver everything, not just a JPEG that I can use at the end of the day, but all of the different variations of it, because that's what you did while you were working for me. And you're thinking, all I had to do was give them this. There's no meeting of the minds. And the only way to make sure that everybody's on the same page, Chris, sign the same page.
You guys hear the theme? Have a shared document that says this is what we're going to do, and let's just get that business stuff done with. Because artists, designers, creative types, we're dreamers, we hear what we want to hear, and that's what makes you guys great. You see the world not as it is, but as how it should be. But you apply that same kind of thinking to the contract. This relationship's going to last forever. I never said that. You're going to, you hear all these crazy things. You got these happy ears that you put on every single day. Okay? For the time in which you're not creating things, take those off, put in your business ears and listen to what's going on. Have a contract, have a document. Let's get done with it. We need to end this, but we're going to end with Rob. Rob, here we go, dude. Okay. Mic drop.
I have something that's kind of, it relates, but a little bit different. Because we've been talking about visual, graphics, and audio. What about software? So I run a development studio, and we've been doing stuff for clients for a long time, and now we're pushing into doing our own proprietary SaaS type stuff. What are the things that we should be thinking about in terms of IP rights and protection or documenting? Because in terms of copyright, you submit a graphic to the Library of Congress, but I don't feel comfortable submitting code to. So what do we do?
Good question. Interestingly, code is considered a literary work. It's the same copyright registration as a book because it's words on a page, essentially. When you're dealing with source code that you don't want people to have public access to, the Copyright Office will allow you to submit kind of the first 50 lines and the last 50 lines or some segment that I might be off on the 50 lines. But they do allow you to do that. And there are ways that you can submit the work and still keep it proprietary and confidential. But it is copyrightable subject matter. You own the copyright in it as soon as you hit save. And it's not subject to a work for hire agreement because it's not an audiovisual work or one of the other designated categories for work for hire. So if someone wants your software copyright, they actually have to have you assign it to them. That says, I hereby grant you the copyright in my software. And if you don't do that, you still own the software. Now, one of the things that happens with software is software can be used to create something else. So I'll have HTML code, but then when you look at it through a browser, it's this very pretty thing. So you'll have what's called a GUI, a graphical user interface, that's generated by code. Well, people can generate this graphics using different code. So sometimes you have to register both copyrights, both in the underlying software and in the look and feel or the graphical user interface. And, okay, it's 2 filings with the Copyright Office. But if you file your registrations, if anything happens, then you have both the proof that your software was already done, and you have the opportunity to sue for additional damages. And sometimes if you say, look, we're registered, here's our evidence, here's this, we're going to get attorney's fees from you, punitive damage, you may not have to sue. It gives you a whole lot more leverage than, hey man, that's my software and you took it.
Why did you say it like that voice though?
Because some people don't take their art seriously. And if I recall correctly, part of this is the business of art. And business is important. You treat it like business and you create art. But business still is business. All of you have to eat. I'm positive of that. You don't always have to drink, but sometimes. So make the business business and do it the right way. And yes, it will cost you more money up front to hire subcontractors that are in the US, to license pre-existing work that you want to use from legitimate license houses, to hire a lawyer to draft a real agreement for your first big client. These things all cost money, just as it costs money to drive to work.
Okay, so here's the deal. I want to summarize a little bit. Okay? First of all, I want to thank Stuart for coming by. And I expect our relationship to continue for years moving forward. And he totally crushed 1,000 entrepreneurial spirits in this one conversation. I can see the lifeblood sucking out of you guys. So one is like, oh my God, lawyers are, and the legal system is killing all of us. And I can see all of you guys, the eyes are rolling in the back of your head. We also learned today that Frank is going to China. And that's the end of that. Suing is no fun. Suing is no fun. You think you're super creative. You think you invented everything. You think you're so original because mom told you so. But you guys got to get over that. Let's start acting like real business people and conduct ourselves in a biz-like manner. This is the part that you need to learn. If you want to be an entrepreneur, if you want to be successful, this is what you got to do. All right, dude, you just killed my outro. Aaron, what do you want to do now? Go ahead.
So it sounds like just generally speaking, I can kind of, if I'm kind of small time like I am, I can kind of pretty much do whatever I want, and as soon as I get a letter to stop doing it, I just stop and we're good.
Wait, are you speaking for Aaron? Who's saying this?
No, I feel like that's what everybody's kind of thinking. You know?
Yeah, okay. So Aaron is kind of, I don't know why he's here, because he's a little shady. He really is. His whole principle is like, I'll steal, I'll take, and when I get caught, somebody will say, like, don't do it, and I'm all good again.
Yeah, and there's, sometimes there's a store down the street and they leave the front door unlocked, and you can go in and you can pick up a brand new television set and you can bring it out to your car and put it in, and it's all fine unless you get caught, right? Is that the question that I was asked
pretty
here?
much it.
Pretty much it.
He's saying, I'll break the law until somebody says something and I'll stop.
All right, and you hope that all they'll say is, bad boy, don't do it again. Put that TV back. Just because you're small time, does that mean you have no integrity? Okay?
Oh, he just called you out. He just called you out, Aaron.
Look,
and when you cut this video
and I know you would never walk into that store down the street
you
and
don't know
steal
that
a
about
TV.
You do not know.
I'm hoping. But an artist's work to them is more precious than that TV is to the retailer, where he's got 50 of them there. Taking an artist's work, man, that hurts them. It also hurts their livelihood. And if you want your work respected when you get bigger, then respect others even when you're a small fry.
That is probably an excellent way to end this, you guys. It's the attorney who's going to teach you creatives about the word integrity. That's it. You guys, please help me thank Stuart for being here. He's been very gracious.
Thank you. Thank you.
And are we cutting?